I'm really excited to introduce this next portion of our program, which will start with some remarks from Professor Ed Cheng, also joined by Professor Collins. Professor Cheng holds the Hess Chair in Law at Vanderbilt Law School. His scholarship focuses on evidence, the interaction between law and statistics, and more recently, remedies. He is also the host of Excited Utterance, a podcast on scholarship in evidence and proof, is a former chair of the section on evidence of the Association of American Law Schools, and helps organize the annual Evidence Summer Workshop. Professor Cheng, take it away. Thank you so much.
So thanks. First want to thank Taylor Ann and Alyssa and Julia for inviting me to do this live recording of the Excited Utterance podcast today, and to Professor Erin Collins for being the test subject or guinea pig or however else you want to describe it. It's actually great to see a number of Excited Utterance alumni here, and hopefully some future interviewees as well. Before we do the recording, I thought it just might be useful to say a few words about the podcast itself, where it came from, the vision behind it, some of the mechanics of running a podcast, so you too can join the podcasting world, and finally, just a very brief retrospective on the podcast over the last 7 years, kind of what the things I think it has accomplished. So first, origins. My desire for a regular workshop series in evidence law was, in fact, the origins of the podcast. So back then, there was no evidence summer workshop. There was actually, I think, a lull in the number of evidence symposia that were ongoing. I think some of this had to do with demographics. There was a pretty large cadre of evidence professors who retired or passed away, and they weren't doing symposia anymore. And then the AALS, the major association of law schools, they stopped doing mid-year meetings. So there was a mid-year evidence meeting, I think in 2007 or 2006, and that was really great, and then they weren't doing those anymore. At the same time, I thought that conventional faculty workshops were a little inefficient. And the reason why I thought that was faculties often have very few, if any, evidence scholars, and there's considerable travel time and costs associated with going to those. And obviously they serve other purposes, but those conventional faculty workshops don't build evidence community. So the question was, is there a way to use technology to solve this problem? And the idea of the podcast was born. At the time, I had been listening to a bunch of podcasts while driving my children to and from school, and two of them were particularly influential. One was the Freakonomics podcast, which is a highly produced, professionally done podcast, and the other was, I think, a somewhat little-known podcast called Salt of the Earth, which was an interview-based show about entrepreneurs and startups and kind of the trials and tribulations of startups. And those two models taught me a bunch of things. One was that interviews were the way to go, that it's often kind of boring to listen to the same person pontificate for 30 minutes, and also that there's a problem of expertise, that if you're going to be the one talking the whole time, then you have to know a lot of things at a very deep level. So interviews fix this problem, and at the same time, I think Freakonomics and Salt of the Earth taught me a couple of other things. Freakonomics, I think, way too labor intensive. Talk more about the labor associated with the podcast in a minute. And I think Salt of the Earth was a bit too raw. There was lots of background noise, and I wanted it to be a slightly more produced podcast. So the result was a lightly produced interview model that was limited to a recent piece of evidence scholarship. So our rule is usually within the last 2 years, and that creates significant limitations. Sometimes we discover things that we wish that we had actually done, but it's too late to actually put it on the podcast. But I think it keeps the podcast fresh. It also creates some sort of a limitation on the scope of what we're talking about, and it gives structure to the interview that is taking place. So mechanics, how it's run. In the early days, the podcast was once a week, every week during the academic year, 28 episodes a year. Just not sustainable. I mean, the amount of time that we're talking about for that was pretty much crushing. It has evolved to one podcast every 2 weeks, and I share the responsibilities with Alex Nunn, who is now at Texas A&M. He was the original research assistant for the podcast. So those of you who are RAs for your professors, things lead to other things that continue for years and years and years. The interviews, originally done in person. I actually tried to time my conferences and my travel to do the interviews in person. That's very limiting, very time intensive as well. I discovered that Skype at the time worked really well, and now Zoom works really well. So if you shut off all the video features, let the audio record, it's actually, and you get a good headset, the audio quality is really good, and it also isolates the audio stream. So obviously it's not the same as being in studio, but I think it's close enough, and it actually makes it convenient for everyone. Finally, there's post-processing, and doing the interview is 20 minutes or 30 minutes actually. Post-processing is an entirely different matter, and in the early days it would take me hours to mess with the audio and try to fix things. I now have an undergraduate production editor who does this. I do the final mix, but she actually does the lion's share of the audio processing. So that's also a tip for those of you who want to do podcasting. If you can get some help and share some of these burdens, it can work very nicely. And I'm happy to talk endlessly about technical details, about the electronics and the software and the hardware that you have to use to do this. Finally, in terms of results, I think the podcast has exceeded my wildest dreams. Today's recording with Professor Collins is number 149. It has enabled me to meet evidence scholars that I probably would never have met, just because people don't always attend the same conferences, some people don't travel. It sort of enables you to meet people just based on their work alone. And the other thing is that it's been a disciplining mechanism. It has forced me to read very widely and deeply in my field. I have these feeds, and pretty much every article about evidence comes through my door eventually, and I end up reading it. Weekly subscriber numbers now are about 8,000, which to me is frankly bonkers. Podcasts have a lot of reach. If I were to tell you what the target audience was back in 2016, it was the 150 evidence academics in the United States. And these days, I have listeners reach out to me from places as diverse as Brazil and Spain, and this is only in the last 2 or 3 years. And the listeners include academics, of course, but also law students, as I have discovered, practicing attorneys and judges, even undergraduates interested in law school. And one bizarre story I can tell about this is that some of my colleagues know that I'm a rock climber. I was at my gym a couple of years ago, and there was another climber who said, "Aren't you that guy that runs a podcast on evidence?" And he was obviously right. And I think he said that he could identify me by my voice, which I was just floored by. I mean, obviously we were in Nashville, so there's some connection there, but it was pretty bizarre. So the number of people who actually listen to this are way more than I would have ever expected. So anyway, thanks again for the invitation, your support of the podcast, and to the Connecticut Public Interest Law Journal for encouraging me to try out a new live format. So that's what we're about to do. So I'm going to turn on just a couple of buttons, and then we'll be off to the races. Well, welcome everyone to this special recording of the Excited Utterance podcast, live from UConn School of Law and hosted by the Connecticut Public Interest Law Journal. I'm Ed Cheng, the host of the Excited Utterance podcast, and my guest today is Professor Erin Collins from the University of Richmond. Erin, delighted to have you on Excited Utterance. Welcome.
Thank you. Thank you so much for having me. It's my first podcast. It's live. There's apparently maybe 8,000 people listening. What could go wrong?
So your article, and I think the conference generally, begins with staking out an interesting position, which is that the evidentiary rules can be an important medium through which we can discuss or address mass incarceration. In particular, even though you acknowledge that most of the criminal cases these days are decided by pleas, you think that evidence remains important, and that substantive law is not the only place to look. So why is that?
Well, I think for a few reasons. One is some cases do go to trial, and so for those cases that do go to trial, the evidence rules are very important in figuring out what information is given to the fact finder. But for that vast number, and I'm thinking particularly in the criminal legal system, which is where my past practice experience and my scholarship focuses, the vast majority of convictions are the result of plea deals. But I think many would agree that those pleas are negotiated in the shadow of trial, and a big part of that shadow, the shadow that is cast by trial, is what evidence is going to come in or is not. So I think the assumptions and the forward-looking assumptions about what evidence will come in should this go to trial are very informative in thinking about how, whether, and when somebody should take a plea or decide to go to trial.
So let me drill down a little bit. The primary focus of your piece is on character evidence and what you call the broken promise of the character evidence rules, the criminal law system. Let me give you a chance to expound on what you mean by broken promise and why excluding character evidence is an important part of maintaining a just system.
Sure. So kind of the starting premise of my article is that those of us who care about decarceration and abolition should start to take seriously what happens when cases do go to trial and what happens specifically under the rules of evidence. Because I think it is a site that's been overlooked as a target for reform. There's lots of work on policing, there's lots of work on sentencing, there's lots of work on prosecution, and evidence law hasn't been taken seriously as a focus for reform. And in my article, I use this idea of the broken promise as just one example to show the ways that the rules of evidence can work to the detriment of folks who are accused of crimes and to the benefit of the prosecutor and the state who are seeking through the criminal process to get a conviction. And the promise I'm talking about is the promise that underlies what's now embodied in Rule 404 but the rule against character evidence. And it's a promise, and this was referenced in an earlier panel, that was articulated. It's been articulated in many cases, but the one I think about is People versus Zakowicz from the New York State Court of Appeals. And then Chief Judge of the New York State Court of Appeals, Cardozo said, the principle that underlies the 404 ban on character evidence is that when a defendant stands before a jury, they should start their life afresh. So essentially, the principle is that we want a fact finder in a criminal case to assess the evidence and judge a person for what they're accused of doing, not for who they are. And that's the common law insight that leads us to Rule 404, which is the rule against character evidence. So just for those who aren't well versed in evidence, right, the rule is essentially we don't allow any party, but particularly what I'm focused on is the prosecution in a criminal case, at least in theory, right, to introduce evidence that someone has a certain character trait, or to introduce evidence of a specific act that shows that somebody has a certain character trait, to suggest that they acted in accordance with that character on a certain date, and therefore have a propensity to commit a certain kind of crime. We don't want to keep that evidence. We don't want the jurors to engage in that kind of reasoning. We want them to focus not on who someone is, but what they did. And so I use this principle, this promise, which is central, one of the fundamental tenets of evidence law, as a starting point, explaining what the promise is and then highlighting ways that I believe this promise is broken repeatedly for folks who are accused of criminal actions. And I could give examples, or if you want me to just...
Yeah, so I'd like to get into at least some of those examples, time permitting. Let me start with Rule 413 through 415. These are the rules that effectively allow us to ignore the propensity rules, at least under the federal system, in cases involving sexual assault and child molestation. Tell us a little bit more about how those rules contribute to mass incarceration and the concerns that you raise in the paper.
Sure. So, I mean, the proper application of Rule 404 would, if somebody is accused of, for example, committing robbery, the government shouldn't be allowed to introduce proof that they committed robbery on a prior date to prove they're the kind of person who commits robbery, to prove they have a propensity to act in this way, to prove that they committed the robbery they're charged with, right? Except we have, through Rules 413 and 415, carved out explicit exceptions to this rule federally, and it's been adopted in a number of states, that when somebody is accused of particular types of crimes, specifically sexual assault or child molestation, we do allow propensity reasoning. So in other words, the promise that you will not be judged by what you've done in the past is explicitly broken in cases involving sexual assault and child molestation. The reasoning for adopting these rules, first of all, the passage of these rules was deeply political. It bypassed, these rules were passed in a way that circumvented the Rules Enabling Act, which is the traditional rulemaking process for the federal rules of evidence. They were adopted by Congress as part of the 1994 crime control bill. They were actually, like, across the board critiqued because we claim so centrally that this tenet that we don't allow character evidence to support a conviction, people were concerned, people were outraged. Even then Senator Biden, who was the primary sponsor of the Violence Against Women Act contained in the same crime control bill, critiqued this particular, spoke out against Rule 413 and 414 as breaking this fundamental idea that somebody should basically be judged for what they're accused of doing, not for who they are. Nevertheless, these rules were passed. And so I identify these rules as one way that the rules are explicitly and intentionally broken in order to help secure convictions. The justifications for the rules are twofold. One, that the propensity inference, the logic, tends to be true in these kinds of cases. In other words, and these are not really supported empirically, but the assumption is that people who commit sexual assault tend to recidivate in this same way, tend to commit these crimes again and again, same with child molestation. And second, that and I think this is what I think many would say is the real reason behind these rules is that these are hard to prosecute cases. And because they're hard to prosecute cases, the government sometimes doesn't get the result that they seek, which is a conviction. And so therefore, we need to relax evidence rules in these cases to allow in evidence that's quite persuasive to the fact finder in order to help get that result that the government seeks, which is a conviction. So this is one way that the rules are changed explicitly with an eye towards helping the carceral apparatus through the securing of convictions.
So I'd like to push back on the critique and pursue that second line of inquiry that you made, which is, so for years I thought that rules 413 through 415 were basically an unprincipled exception that targeted groups of people that we simply didn't like. But I've had some second thoughts of late, and I think it's particularly in the wake of the Me Too movement, where sexual assault complainants often found themselves deriving a lot of strength from multiple accusations from other people. So banding together does in fact bolster the testimony. And this is kind of the theme of the conference here, which is how do we empower the disempowered through evidence rules? Seems that 413, 414 might be a mechanism for doing that. Still unfair and undesirable.
That's a good question, and my answer is yes. Me Too has brought to the surface and made us confront many things that many of us already know, right? Which is that many instances of sexual assault are underreported. Many people who have experienced sexual assault are not believed, right? But the thing about Me Too is it's all happened, it's continued to happen despite the fact that we've had 413 through 415, right? 413 through 415 have been around since the mid-1990s. That didn't solve the problem, right? It shows that people who have experienced sexual assault still aren't achieving justice in ways that they want or need. The continued kind of myopic focus on responding to harm with the criminal system is not keeping people safe from sexual assault or child molestation. So I think in the big picture, it's showing that this problem persists despite tweaking evidence rules. It also shows that a problem that these rules are trying to address, which is the credibility contest that often is decided in favor of whoever is more powerful, right? And that usually is a white cis man, right? Those credibility problems persist despite 413 through 415. So I think it makes us confront the idea that the credibility contest can't be fixed necessarily by changing evidence rules, right? And I think part of the problem remains a societal problem of bias, prejudice, stereotype by decision makers, by lawmakers, by jurors, by judges, right? Who are the ones who are empowered to decide what happened and who are empowered to decide who to believe. Those problems persist. And then the final thing I'll say is that I think I want to also distinguish the ability and power to meet people where they are and to believe them just based on their word out in life as friends, as mentors, as community members, versus the consequences that flow from the criminal system, which are different, right? But you can show up for people who have been harmed in your community, in your schools, in your households, in ways that advance and show and underscore that you believe them, and there can be power for everyone in many people coming forward. I don't necessarily think that means that therefore we should do the same thing in the criminal courtroom when the stakes are, the consequences are conviction and incarceration. I think if we have this promise to folks that you are judged based on what you're alleged to have done, not who you are, and that we don't allow propensity reasoning, I think everyone, even especially in the hard cases, everyone should benefit from that protection. I think we should resist the urge to exceptionalize hard cases and essentially reduce the burden on the government to prove their case beyond a reasonable doubt.
I'd like to turn to Rule 609, which is another area that forms part of your critique. Rule 609 we've talked about a lot today. It's the rule allowing prior convictions to be used to impeach defendants, actually all witnesses, but defendants most problematically by suggesting that they have a character for untruthfulness. The interesting thing about 609, I think, is that I think most of us might agree that the use of felonies to show character for untruthfulness has a kind of dubious logic and has a dubious history. The problem is that I think elimination is, I don't know, I mean, I think Julie Simon Kerr and Anna Roberts might have something to say about that they might say that it is possible. But I'm going to operate on the notion that it might not be possible to completely eliminate that rule. What should we do about that rule? Are there things that we can do short of elimination? One possibility that I think in my mind is to force or somehow encourage judges to simply apply the balancing tests that are different in that space more rigorously than they perhaps have been.
So I wish I could since we're live, tag team in some of my colleagues here who are the true experts on this topic. But I'll just kind of articulate how my 609 critique connects to my larger paper, because it's another instance, right, in which folks, and particularly I'm focused on folks who are accused of crimes, when they testify in their own defense, they can be impeached with their past convictions, right, under the theory, the dubious theory, the theory that I think many of us would agree is weak at best, that the fact of criminal conviction tells us something about someone's character for truthfulness, right? And it can have real impacts on keeping people from testifying, or when they do, jurors tend to use this evidence for a variety of different reasons. The question is what to do about it. I guess I wouldn't want to take complete abolition of that rule off the table. I think Professor Simon Kerr and Professor Roberts' work has shown that there are jurisdictions that have taken it off the table, so that would be my first best solution. Second would be severely limiting the instances in which it can be used, and again, I'm drawing directly from their articles and their proposals, which is saying maybe not at all for criminal defendants or anyone, but if at all, then really taking seriously the notion that the theory of relevance is it tells us something about someone's character for truthfulness, so we should limit it only to convictions that involve some kind of untruthful act like perjury. But short of those kind of like restrictions on the rule itself, I think you're right. I think we need to expect more of judges in the balancing and expect more in the parties who want to use the convictions to impeach, to articulate how does this particular conviction tell us something about this particular person's character for truthfulness, right? How does the fact that this person was convicted of possessing a weapon tell us anything about whether or not they're truthful under the stand, on the stand, because that's what's missing in courtrooms a lot, right? And that's how judges just come to this kind of quick, and they'll say they're doing some balancing, and then they'll say, okay, well, maybe we'll just say felony, but we're missing the part where the party, and usually the government here, has to actually articulate a theory of relevance about how it bears on character for truthfulness. I would love to see more of that, and then judges taking that more seriously and really applying all of the different factors they're supposed to apply. I think that could lead to some better decisions, but I'm not giving up hope on complete abolition of this rule.
I'd like to return to your opening thesis, which is the focus on evidence rules to try to address mass incarceration. And you chose in the article to focus on the character evidence rules. But you know, if we're taking this seriously, I think that there are other evidentiary rules that are possibly on the chopping block. And one was mentioned earlier by Bennett Capers, which was 410. 410 encourages pleas. I think pleas lead to easier prosecutions and therefore mass incarceration. So why the focus on character and not 410, or maybe you'd like to add 410 to your list?
Yeah, so my focus on this idea of a broken promise was just one framing technique, because I mean, all of the rules could be in this critique, right? I think all of the rules, many of the rules, maybe most of the rules, can be interpreted and applied in a way that is consistent with power dynamics and it kind of helps the prosecution certainly more than it helps the defense, right? So it's not meant to be exhaustive. I think we can look at other promises that are made to folks who are accused of crimes, like the promise, implicit or explicit, that you won't be more likely to be convicted if you are black or brown, right? I think that promise is broken all over the place in ways that have been illumined by the scholars in the room here. But 410, I think, would be another interesting site of reform, though I have to say, so 410 is the rule that says that proof of plea negotiations that result in pleas that are withdrawn, or a no contest plea, or that don't result in any plea at all, cannot be admissible if someone goes to trial. I guess I'm a little curious to know how much of an impact that actually has on someone's decision, because, and I'll admit this is hearsay within hearsay, but a long time ago when I was first prepping for evidence, Professor Golden kindly shared many of her materials, and in her materials is a reference to a conversation with a federal prosecutor who said essentially, if there's no 410 waiver, it's not plea bargaining, right? The plea, because 410 only applies to conversations that are considered plea bargaining. I think it's routine, or at least I hear it's routine, that federally, many prosecutors, before they will bargain, require a 410 waiver, right? So we're already doing a workaround of that. So I guess I'm cynical that it really has a lot of teeth, though I'm open to considering that it does, but I'm with you that I think we need to reconsider all of the different processes and systems and policies we have, including Rule 410, that assume we must keep, that plea bargaining is a social good, and that we must keep plea bargaining as a central part of our system and allow it in certain ways in order to keep our system functioning. This pervades criminal procedure adjudication, which I also teach and write about. I think we should revisit all of that, because I think the more we just facilitate plea bargaining, the more we're working in injustice and lessening the burden on the government to actually have the evidence to back up its allegations.
Here's my other broader question for you, and I think it has to do with a tension that I sense in the article. So part of the article, and I think, in fact, part of this symposium, is really about emphasizing outcomes. In your case, it's the outcome of reducing incarceration. And in fact, there's this great line in your article which says, quote, "We should start by being honest about how particular rules shape outcomes into predictable patterns." And yet, at the same time, I think there's an emphasis in the paper, I think quite understandably so, of improving accuracy. And that gets to this longstanding debate, and you talked about this tension earlier in the conference, between accuracy and other concerns. I think Professor Simon Kerr talked about it as being justice or fairness. Where do you draw that balance, or how do you think that balance can be best done?
Ooh. I don't know if there's a perfect equation, but I will say the equation we now have is out of balance, right? I think there is an assumption that what we should be seeking is primarily accurate, truthful outcomes, and I think, as I alluded to on the panel earlier today, the rules aren't just about accurate outcomes, they're also about just determination. So I do care about outcomes. I think accuracy is also an important value, though I would also posit that what we see in the criminal system, like the people who are brought into the system and prosecuted, is not an accurate glimpse of the population of folks who have caused harm and who are harmed themselves. I think it's a slice, and it's a specific slice that is taken in the context of a system that has deep roots in white supremacy, of who gets charged with crimes and who comes to this system. So I think we need to think about accurate outcomes, but we don't have an accurate sample of kind of what is actually happening in the world. And another one I'll just add into there is it's not just accuracy and it's not just outcomes, but it's also the integrity of the process by which we arrive at those outcomes. And again, there's principles in criminal procedure that we're supposed to care, not like society wins, the court said in Brady, not just when the guilty are convicted, but when essentially the process is fair. And I think we've lost sight of the fairness of process when we're interpreting and applying a lot of these evidence rules.
Final question for you. What's next for you on this project or otherwise?
Oh my gosh. Well, first, I just want to stay in conversation with and kind of keep the momentum and the energy that has been produced through this wonderful symposium, because I think together we can generate a lot of amazing scholarship, conversations, and actual meaningful reform. I would love to get involved with on-the-ground reform efforts to change some of these problems that we've all been observing. And meanwhile, I'm working on a paper with Ngozi Okitaba from BU about the obsession, kind of the obsession within the critique of algorithms in the criminal legal system on getting accurate outcomes, and kind of the collapsing of notion of fairness into accuracy and equally accurate results or errors. And what we're doing is actually we're looking to evidence law as a model of how a system can, at least in theory, if not in practice, value accuracy and other values like justice and fairness when assessing what should happen. So I'm excited to see where that leads, and I'm excited to see where the rest of this conference leads.
Well, Erin, thanks for being a good sport and agreeing to do this first ever live Excited Utterance podcast. Great having you on the show, and thank you to everyone here at UConn Law for being a terrific audience.
Thank you so much for having me. I survived.